Greetings and various assorted salutations. Welcome to another U.S. government lecture. Today we're going to be looking at the first 10 amendments, also referred to as the Bill of Rights. Now, the Bill of Rights were passed initially in 1789 and then ratified in 1791. This is the only time where we have a whole bunch of amendments put through all at the same time. Typically, amendments are done one at a time. So just getting into it here. Now, these first 10 amendments were added to the U.S. Constitution at the behest or the request of the Anti-Federalists. If you recall from prior lectures or course materials or even previous U.S. history classes, the Federalists and the Anti-Federalists were the big debate of early America. How much power should the government have? And the Federalists, they are the primary framers and writers of the U.S. Constitution, and they're the most favoring of it. However, a number of states and a number of anti-federalists felt that the U.S. Constitution didn't quite have enough guarantees within it to protect the American citizens. And so this was added to the U.S. Constitution. Amendments are changes to the Constitution. If you want to think of them as kind of being stapled onto the Constitution, that's kind of what they are, is they're additions. But let's take a look at the first 10 amendments. Now, the First Amendment is often one of the most fondly thought of, and it is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging freedom of speech or of the press or of the right of people to peaceably to assemble and to petition the government for redress of grievances. This First Amendment is the amendment of our basic freedoms. Freedom of religion, freedom of speech, freedom of press and assembly, and the right to petition the government for change. These are all excellent things that are frequently cited as hallmarks and foundations to the U.S. Constitution. However, they were not in the U.S. Constitution itself. They are part of the Bill of Rights, which is kind of a fascinating thing to think about. Just to run through some examples, with freedom of religion. Freedom of religion is something that was relatively new in this era. Most governments in the world in the 1700s had a state religion, and the government was kind of the head or heavily influenced the religion. And so as a result, people were strongly encouraged to be the religion of the government. And the United States was founded by a number of refugees or people who did not share the same ideas, same religious beliefs as the government they had left. For example, Maryland was founded by Catholics leaving England. The Puritans, the Quakers are all different groups. And so the United States, in its Bill of Rights, guarantees freedom of religion. That's perhaps why it's one of the first things mentioned. The freedom of speech is another big one. The right to express your opinion, the freedom to do so, is held up as one of the hallmarks and one of the most important things of American democracy. Is the ability to speak your mind, whether it be on paper or on page. The freedom of speech debate and argument has gone well beyond the initial imagination of the founding fathers now with the internet and whatnot. We also have the right for people to peacefully assemble and the freedom of the press. With peaceful assembly, this is an important one as well. Not all nations give their people the right to publicly protest. And the reason why public protest is such an important tool for many issues is often people are, well, quite frankly, ignorant of what's going on. And a protest or a march is a way of building awareness of an issue or topic. The civil rights movement, which you studied in a prior U.S. history class, is an excellent example of this. There were people who weren't fully aware of what was going on with regards to civil rights until protests made the issue more apparent. Freedom of press is also an important one. The news is who we usually think of, but the idea that you can report the truth, you can report what you think, you can report these things. In many parts of the world, the press was heavily limited or restricted. The government didn't like news coming out that ran counter to their agendas or did not put them in a favorable light. Those are examples of that. The last one in here is one that we often forget, but people have the right to petition the government for redress of grievances, or they have the right to issue petitions. Now, we see this right to petition more locally, sometimes with state initiatives or things of that nature, but I can't resist citing it. But one of my favorite petitions ever issued to the United States government is under the Obama administration. A number of Americans, Democrats, Republicans, all came together in a united desire and put forward a petition for the presidency to initiate the construction of a Death Star, as seen in the hit film Star Wars. The creation of the super laser, the petition argued, would create jobs. It would stimulate industries. It would guarantee American defense. Unfortunately, the administration rejected this petition and explained that it just wasn't cost effective, and it seems a bit unrealistic to have a planet-destroying death laser for the defense of the United States of America. So just because you can petition the government doesn't mean they have to humor your request. But anyways, moving on. Now, the Second Amendment is one of the more controversial ones. I'll read it as it reads, and it is a well-regulated militia being necessary to the security of a free state, the right of the people to bear arms shall not be infringed. Now, this Second Amendment is often called the Gun Amendment. It's the one that allows many Americans to own firearms, exemptions being predominantly convicted felons, I believe. Many countries in the world do not allow their populace to be heavily armed, or if they are, they're usually affiliated with their workplace as a security force, or they have to have special permits and extensive restrictions are in place. But the United States has some gun restrictions. There's background checks, there's waiting periods, but for the most part, in the United States, the right to bear arms has been widely available to many Americans. You can see how it might be a topic of controversy. Now, the Third Amendment is no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner prescribed by law. This is a direct reaction to the Quartering Act. We here in the 21st century really haven't encountered this, but those who lived through the colonial period and the American Revolution do not fondly remember the British soldiers that were quartered in their homes during the Quartering Act. So this Third Amendment hasn't come up as much anymore. But it was very important, especially in the early days of the United States, because that was something in people's memory. Like, for example, Andrew Jackson, one of the officers that was assigned to his home, or one of the soldiers assigned to his home, struck him when he was a bit lippy. Which you can imagine Jackson, being he must have had an interesting childhood. But that's kind of the idea here. Probably the last time we had a lot of talk of the Third Amendment would have been around the time of the American Civil War. Moving on, the next amendment is the Fourth Amendment, and that is the right of people to be secure in their persons, houses, and papers and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this one is about search and seizure. It's more complicated. We'll talk about this more in the judicial branch when we get to it. But this amounts to is the government cannot just kick in the door to a person's private home and seize things without good reason. There's a procedure for this. Often the to do a search and seize things from a person's private property, a warrant must be issued, and the warrant explains why these things are being searched and what they're expecting to find and things of that nature. And so the idea of the Fourth Amendment is the government has to play by a certain set of rules before it steps on a person's property and things. The Anti-Federalists liked the Fourth Amendment because it gave protection to one's personal matters. But now the Fifth Amendment is on the rights of the accused. No person shall be held to answer for capital or otherwise infamous crime unless presented on indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This one is a doozy, but it talks about, okay, when you are accused of a crime, there are certain procedures we have to go through. You cannot be charged for the same crime, the same particular criminal offense twice in a row. So if, say, you are accused of murder and you're found innocent, you can't have a new court case about that murder come up again and say, well, that's what double jeopardy is we'll just run the case until we get the answer we want. Cases have to be appealed. You have to go through a procedure. And if you don't like how a trial went, you have to take it to a higher court. This stuff that I'm mentioning here is outlined in more detail in other parts of the U.S. government law and code and whatnot, but that's kind of the purpose of the Bill of Rights. Is remember, it's connected to the U.S. Constitution, and the U.S. Constitution is the highest law in the land, and it also serves as the instruction manual. We have laws and codes and regulations that further detail and expand upon all of the amendments in the U.S. Constitution. Because our law is a lot more than just this, but this is the level zero, the base level of the of U.S. law. Another thing that's in there is due process of law, and this bit here about how nor shall be compelled in any criminal case to be a witness against himself. When you are accused of a crime, you are innocent until proven guilty. And what that amounts to is you are not required to defend your guilt. Maybe I'm not explaining this the best, but the people who accused you, the accusers, must prove you guilty. And you are not obligated to provide them with any tools to prove yourself guilty, nor can you be forced to prove yourself guilty. Through, for example, like interrogation or torture. But that's the idea here. And once again, you can't deprive somebody of their life, liberty, and property without due process. The idea there. Now, the Sixth Amendment is very much connected to the Fifth Amendment, connected to the Seventh and the Eighth Amendment. A lot of this deals with what can the government not do to a person when they are accused of a crime. That's what a lot of these are dealing with. Now, with the Sixth Amendment, we're looking at in all criminal prosecutions, the accused shall enjoy the right to a speedy trial, a public one, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature, the cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. The Sixth Amendment is, how does one go about carrying out trials? Speedy, admittedly, the courts don't feel like they're fast, but that's probably because they're a bit overtaxed. Public, you can go watch court cases. Many court cases are open to the public. And they're being heard by a jury, which is something that comes up. What this part here is a jury from where the crime was committed. This is where the kind of the anti-federalist appeal comes in. Remember, anti-federalists were very concerned about government being divorced from the people. And so what this amendment says is, look, at when you are accused of a crime, the people who shall hear and review your crime are local to the area where the crime was committed. That's what this jury is all about. Is the jury is made up of residents of that area where the crime was committed. Now, sometimes there'll be cases where the where the case is moved to a different area, but those are exceptions, and that would be done in case they feel a fair trial cannot be done within the community where the crime was committed. But that's all stuff that's covered outside the bounds of the Sixth Amendment. It's clarified through the laws and regulations beyond it. But no, so there's a lot of other stuff in here. There's the basic explanation of how law works. You must be informed of the crime you've committed. We're not just throwing you in prison, hauling you before a judge and saying death penalty. This is not Franz Kafka's short story, The Trial. You are told and explained what law you broke, you've been accused of breaking. You are then going through a process of reviewing, okay, what's the evidence? What happened? Who saw it? There's a certain procedure for asking people about what they saw. And you have the right to professional assistance should you want it. Once again, that'll be stuff we talk more about in the judicial branch. Moving on to the Seventh Amendment. In suits at common law where the value of the controversy shall exceed $20, the right to trial shall be preserved, and no fact tried by a jury shall otherwise be cross-examined in any court of the United States than according to the rules of common law. So common law is something that we talk about more in the judicial unit. It's something we talk about elsewhere. But the basic idea of common law is this is drawn from the English tradition. Common law is the idea that we have these laws, and in the past, we have looked at people who broke those laws, and we've weighed the punishment, we've weighed the evidence, and we've explained, okay, this is why we enforce the law this way. And when a court case is brought forward, common law basically says, okay, let us look at what we have done before. How does what we have done before apply to this circumstance? And then we use that as part of the explanation for how the court makes its decision. This comes up a lot in Supreme Court cases in explaining, like, okay, where are these ideas coming from? The idea of law enforcement does just not magically appear in a vacuum. There's what has been done before, what has been voted, what has been chosen before, and how people have reacted in the past that is factored into the present and future, naturally. Number 8 is a short one, finally. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, this one's important because it means that punishments should not exceed the crime committed. Now, you'll notice it's very vaguely worded because it's like, okay, what's cruel and unusual? What's an excessive fine? What's excessive bail? These things are things that are debated and argued about even to this day because things have changed over time. For example, when we talk about excessive bail, money has changed in value over the decades since 1791. And so fines from 1791 may not make sense to people today. That's why we don't build the fines into the U.S. Constitution, the Bill of Rights. They're put into laws and bills and things and codes elsewhere. Likewise, cruel and unusual punishment. Well, what is cruel? What is unusual? I mean, in the 1600s, it was neither considered cruel nor unusual to put somebody in the stocks and throw rotten fruit at them in some areas. The death penalty was very different in the 1700s and 1800s than it is today. Some people argue that the death penalty is morally wrong. And so it's one of the things is the Bill of Rights and the U.S. Constitution and the amendments that follow, they are intended to clarify a lot of how America should be run, but sometimes those clarifications acknowledge that these are ongoing debates, and quite frankly, things will change over time. So keep that in mind as you're reading it, because just like up here with the Third Amendment, people in the 1790s would have been very interested in making sure the Third Amendment is maintained. Us in the 21st century, at least not at time of recording, this amendment is the one that doesn't come up as much. You're more likely to be thinking about the Fourth Amendment or the First Amendment, for example. Moving on, the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, what this is referring to is the government cannot make laws that contradict the Bill of Rights, the amendments to the Constitution, or the U.S. Constitution itself. You can't put in a law that negates freedom of speech. You can't put on a law that negates the Eighth Amendment, for example. And the reason for this is because, remember, the United States government is a government for the people, by the people. And if the Constitution is the highest law of the land, you cannot have things that contradict it, because that would violate the agreement between the government and the people. That's the idea there. The 10th Amendment is the last amendment to the original 10 amendments, the Bill of Rights, and it is the powers not delegated to the United States by the Constitution nor prohibited to it by the states or reserved for the states respectively or to the people. Now, what the 10th Amendment does is it clarifies that, okay, there are certain powers or responsibilities that the U.S. federal government in Washington, D.C. handles. Things like defense, things like that. But there's also other things that are handled at different levels. For example, most education decisions are handled at the state level. And it's a kind of a state's right that the state decides kind of how education is run within its own boundaries. But sometimes there are things that are not handled by states. For example, there's a lot of city laws that only apply into the city that you're in. And that's because, okay, if the federal government doesn't do it, the state government doesn't regulate it, the cities might regulate it. And if it isn't up to the cities, if the cities aren't addressing an issue, then it's something for the people. The idea of the 10th Amendment is it outlines federalism in that there are certain responsibilities handled at each level of governance. And if it isn't handled by any of those levels, it's an issue for the people. But that's the idea there. Now, that's the basics of the first 10 amendments. In class, we'll go into more detail on this resource page that I'm pulling from. It goes into more detail about things. But this is just a basic overview of the Bill of Rights. It's a byproduct of the Federalist versus anti-Federalist debate, but the Bill of Rights is a foundational piece of the U.S. Constitution, and many Americans can't imagine a Constitution without the first 10 amendments, which is something to consider its impact on how our government and nation is run and history has progressed. Anyways, that's enough for now. Until later.